Okay, here it goes. Well, I'm not sure it can move or not, but the point is, even if you move it, it's going to still pick up a lot of the stuff that's in there. So, okay. So, in any event, good evening, everybody. We're going to jump into sort of immigration overview here and figure out what's going on with immigration. Now, some of you told me that you wanted some additional assistance on immigration, so I figured out, let's do this, let's get this going. So here we are today. We've covered several weeks of immigration already. We have covered many topics. The only topic really that's left to be covered is essentially judicial review and administrative review. So we'll cover some of that later in the evening, but there's some slides in this presentation that deal with judicial and administrative review anyway. So having said that, without further ado, let's get started. Okay, so who makes the immigration law? We've talked about that already. Congress passes the laws. There's regulations that are implemented by various agencies. There's a disturbing trend now with USCIS, which I've discussed with you, also USICE, called policy memoranda. So what the USCIS or USICE are doing is they are taking essentially the regulations or the laws or the executive orders, and they're saying, based on these, this is now going to be our policy. Now, it's not a regulation, it's not a law, but that's how we plan to implement the regulations, which really becomes very tricky and very nasty because we are now going away from a government of rules and laws to a government of men, which is what our Constitution did not want to happen. So we've got some significant problems, and I think there's going to be a lot of litigation coming down because of the reliance of USCIS and USICE on these quote-unquote policy memoranda. Now, I teach only immigration law, so I'm unaware of other areas of law. But I'm sure, just like we are seeing policy memoranda coming out in immigration, I'm sure other agencies are also issuing policy memoranda to change the way that they are implementing the regulations. Okay? So, let me go back for a second. Executive orders, as I already said, that's another source of immigration law. It is not law, it's an executive order, but that's how the laws are being followed. We are going to start looking at some of the executive orders later on when we talk about the chapter on administrative review. And now we also have states getting into the game. So states are attempting to affect federal immigration law and policies by passing different state laws that impinge upon the rights of immigrants, or by creating rules and regulations, for example, with their own health and human services departments that either grant or deny or limit or restrict the rights of aliens to obtain benefits from the state. For example, food stamps for their children, health care for their children, S-chip enrollment, driver's licenses, state IDs, things of that sort. Even access to courts. Some courts have said, we won't let you file a complaint for divorce, for example, if you're not a citizen, which is ridiculous. Okay, so we've got problems that are coming up that way. Sources and interpretation of immigration law. So some of the sources, at the top of the pile, you have international treaties, because as you know, international treaties trump everything else, including our own laws passed by Congress. Statutes, regulations, Board of Immigration Appeals decisions, U.S. District Courts and U.S. Appeals Court Circuit decisions, Administrative Appeals Office of the USCIS, other federal agencies. For example, with the Department of Labor, we have a group within the DOL called BALCA, Board of Alien Labor Certification Appeals. And BALCA determines appeals based on labor certifications that are denied or that may have been approved, or renders advisory opinions if a certifying officer requests it. Also, we have policies and memoranda, which come out from the executive branch agencies, which we just talked about. And then finally, we have the emerging trend of state laws. So those are some of the sources and the interpretation of immigration law. Okay, who implements the immigration law and makes policy? So we've got various departments, starting with the Department of Homeland Security, U.S. Department of State, Health and Human Services Administration, U.S. Department of Labor, Social Security Administration, FBI, state and county agencies, and local agencies, including police departments. Now you will say, how can local agencies make a law that affects immigration? Very simple. For example, a police department may choose to call ICE every time it encounters an alien. Or a police department may decide that they do not wish to call ICE every time they encounter an alien. A county may decide that someone who's an alien and who is in the county jail will be granted bond, and the county will not honor an ICE detainer. Okay? What's a detainer, by the way? We covered this. What's a detainer? Anybody know? What's a detainer? Tell me, Serena. Before ICE comes and picks them up from the police station or jail, ICE issues a document. The document is called a detainer. And basically the detainer says to the jail or the holding facility, please hold this alien for 48 hours, holidays and weekends excluded, so we can essentially come and pick him up. So even if the alien has granted bond, even if the alien pays bond, there have been cases where the jail has continued to hold the alien because they're respecting the ICE detainer, which is not law. It's simply a request by ICE to the jail to hold the alien in custody. All right? Immigrant versus non-immigrant status. We spend a lot of time on this. Now you remember this too, right? So who's an immigrant? Who's an immigrant? Kimberly, who's an immigrant? Mm-hmm. You can look at the screen, and it's not cheating because it's right there in front of you. Okay. No, that's a non-immigrant. Who's an immigrant? Okay, so that's an immigrant. So what does an immigrant get? What document does an immigrant get to show that he or she is a permanent immigrant? A green card, correct. Permanent resident alien. Okay, so they get a green card. Who's a non-immigrant? What's a non-immigrant? Megan, what's a non-immigrant? Right, so temporary purpose, temporary period, it's defined. They're coming here to be what? Give me some examples of a non-immigrant. Nicoletta. Sorry? A tourist, yes, a tourist. What else? Who else? Students, absolutely. What else? Workers, temporary workers. Very good. So those are some examples of non-immigrant visitors. Why? Because they're coming for a temporary period of time and they're coming for a defined purpose. Okay? Now, so what are the broad categories of permanent immigration? Okay, for permanent. So they're coming here permanently, they're going to get a green card. What are these broad categories? First of all, remember, is it an unlimited amount of people? No, it's not unlimited, okay? So the annual cap for immigrants under the family-based category is how many? Does anyone remember? What's the annual cap, maximum number? Nope, a lot more than that. 480,000 with a floor of 226,000. So they cannot issue less than 226,000 family-based immigrant visas, okay? There's also a cap for the employment-based. We'll see that in a minute. Okay, so family. What are the family-based quotas, okay? Family-based immediate relatives. Is there a cap for immediate relatives? No. What's an immediate relative? Tell me quickly. Husband, wife. What else? Children. And what else? Parents. Very good. So parents, children, and spouses of whom? Of whom? Of what category of person? Citizens. Parents, children, and spouses of citizens are in the immediate relative category. Okay? There is no cap. All right. Other relatives are capped by statute. Employment-based. Is that capped by statute? Yes, it is. How many? What's the maximum of employment-based visas that can be issued in a year? Sarah?
I know it's depending on what the employment is, but
No, that's a maximum cap for all employment-based visas. What is that cap? 140,000, which is a drop in the bucket when you compare it to the overall population of the United States. 140,000 per year. Okay. There's also humanitarian immigration. For example, asylum. There's the visa lottery, which is also called the diversity visa, which we heard a lot about just earlier this week when that crazy guy from Uzbekistan went and ran over all those poor people bicycling in Manhattan. Okay? There's investor visa, which is again capped by statute because it's part of the employment-based visa categories, as we'll see in a minute. Okay. So broad categories of non-immigrant visa types. As we said earlier, what's a non-immigrant? Someone coming for a temporary visit for a specific time, and it must be for a defined purpose. They must be permitted to extend their visa or to leave the USA. So they have to, if they haven't completed what they want to do, they must request that their visa be extended, or they have to leave the US. If they stay in the US without extending their visa, what happens to them? They fall out of status. They fall out of status. Very good. Fall out of status is not a good thing. Some of the examples. F. What's an F, for example? Student, very good. Okay, what's a B1 or a B2? Tourist, very good. Okay, all right. What's an H1? Worker, very good. What's a TN? Trade NAFTA. So it's a NAFTA worker. Okay, so NAFTA treaty. Okay, the O1 is outstanding. PQR. Okay, those are some of the visas, and they have no caps except for the H1. So there's no cap on non-immigrant visas except for the H1. Some, however, will lead to immigrant visas. For example, the K1. What's a K1? Fiancé, very good. There's no cap on fiancé visas, okay? The S visa, the T visa, and the U visa are all capped. That's right. So tell me, since you bring that up, Ashley, what's an S visa? No. Try again. Very easy to remember, actually. S visa. S visa, S visa, S visa. Snitch. Snitch. S for snitch, okay? T visa. What's the T visa? Victim of trafficking. Victim of trafficking. What's a U visa? That is a general crime, correct. Usually crime involving violence, so non-violent crime like not trafficking. Trafficking goes under T. Okay, so that's how you remember those. Very easy to remember. Okay, recent priority date chart. Now, I don't want to get into this in tremendous detail and eat up time. Do you remember the priority date chart and how it works? You do? All of you remember that? Okay, all right. So we will not look at the priority date chart on this screen right here because it is something that you already know. I will bring it up just for purpose of the recording so that our students who are not here remember it, but I just want to and there is the priority date chart. You remember this, students, that we had this priority date chart here and we had looked at it, and every month this chart changes. Now you tell me this. What do these numbers mean? What do they mean? These dates, what do they mean? What's a priority date, Sarah? They date they filed the application for the immigrant visa. Correct. That is right. So what does the date mean when it comes out in this priority date chart? What does it mean? If you have a date that, let's say, look at F1, and the all chargeability areas is January 22nd, 2011. What does that date mean? January 22nd, 2011. What does it mean? That's not when they start viewing. That's when they start becoming eligible to get their green card. Okay, so you may have filed the application a long time before January of 2011, but because you have to wait in line, it's a very long line. Remember we talked about that? It's a very long line, and because that line is so long, you're waiting sometimes for years. In this case, someone whose application was filed on or before January 22nd, 2011 is now getting their process completed to get their immigrant visa and come to the USA. You understand? Okay? So, if someone hasn't filed before that date, they're likely to be waiting. Let's say they file it today. They're going to be waiting at least 6 years because that's the backlog right now, almost 7 years. If they file their application in November of 2017, that's almost 7 years they're going to be waiting, maybe even more, because those dates don't move at the same time as the dates do on our calendar. They don't move chronologically day matching day. They move even slower than the calendar moves. So we've got a problem. That's why we've got a backlog. So that's the family-based visa priority dates. Let's go down a little bit and look at the same thing happens for employment. Here's the employment-based. Now, what does C mean? We covered that as well. What does C mean on the employment chart? Current. What does current mean? Now, if you file an application today and it's approved today, you're going to get your green card essentially today as well. So it is basically there's no backlog. But in certain categories, like the second category, preference category, especially for China and India, there's a huge backlog. Third preference, there's a backlog again for China and India, and also the Philippines. So there are backlogs even for the employment-based. The fifth preference is the investor category. Remember we talked about that? People who bring in how much money? $1 million or $500,000 and create how many jobs? 10. Very good. 10 US jobs. Okay, so you got that very well. So that is the priority date chart. Okay, let's go back to our slideshow. So typical immigrant visa process. What happens in an immigrant visa process? This is the typical process that we go through. We've got to look at the scenario that happens, both in family-based and in immigrant and in employment-based. What are some of the major things that happens? For us as attorneys, we've got to figure out who's the petitioner. That's the person filing the application. Who's the beneficiary? And that sometimes becomes your problem as well as attorneys, is who's your client? Because ethically, do you have a responsibility to the father of your client? Yes or no? To the mother of your client? No. You have a responsibility to whom? Your client. Not necessarily the beneficiary. What if the US citizen husband comes to you and says, I got married in Nigeria and I want to bring my wife from Nigeria to the USA? Who's your client? Who's your client? The husband. He came and retained you. He paid you. He's your client, okay? Suppose the husband's father comes to you and says, you know what? My son got married to this woman from Nigeria and he wants to bring her to the USA and I want to pay you to get started on the process. And here's all the information you need and here's the money. Who's your client? The father's your client? The mother's your client? The son who got married is your client, or the woman in Nigeria is your client? Who's your client? The son who got married, correct, because the father is only paying the money. Okay? The son is the one who's got the interest, right? He's the one who's interested in getting his wife over, correct? Right? Okay? So it's the son who's your client. So keep that in mind. So from a practice standpoint, from an ethical standpoint, from a drafting of the retainer agreement standpoint, you're going to put down the son as the person signing the retainer agreement. You're going to give the retainer agreement to the dad. You're going to say, take this home, get it signed, bring it back, and then I'll start working. Okay? Remember, we've talked about this many times in class, right? Okay? What have you got to do? You've got to protect yourself. You've got to make sure that you document. Always have a retainer agreement. We've talked about that, right? Always have a retainer agreement with your clients. Spells out everything. Okay. The process itself is fraught with issues. There are delays. There are backlogs. There are requests for evidence. In family-based cases, you have another problem. It's called aging out. What's aging out? We talked about that. What's aging out? Correct. And what age limit is typically the problem that we have? 21 for children. Correct. So at the magic age of 21, a child stops becoming a child and becomes an adult. Okay? So we've got a problem, right? At that point. What's death? Who's death? These visas are taking years. You saw that with the visa chart. Who's death? The petitioner. Petitioner goes and dies. So inconvenient. So inconsiderate. Okay? And then what? Then the family can't immigrate. In rare instances, if the USCIS decides, yes, there's some humanitarian basis to let these people immigrate, and they can find another sponsor for the affidavit of support because the petitioner has died, yes, then they may allow the family or the beneficiaries to emigrate, okay? There's also another problem, inadequacies with the affidavit of support. The affidavit of support, as you know, is a document that's filed by the petitioner saying, yes, I will be responsible for the financial care of the beneficiaries, and if they fall upon public assistance, I will repay the US government the public assistance that they have taken. So sometimes the affidavit of support may be inadequate because the sponsor himself or herself has to have at least 125% more than the federal poverty line for that number of people in the beneficiary's family that's coming over, as well as the sponsor's family that's already in the USA. So that total has to be 125% of the federal poverty guidelines. Everybody with me so far? Yes? Okay. All right. With the employment-based immigrant visa side, we have its own set of problems. For example, there's company closure. Companies go in business, they go out of business. Companies are sold. Companies are bought. The purchasing company may say, we've merged with this company. We don't need all these extra employees. We're going to keep our own people because we know them and we love them and we have a relationship with them. We're not going to keep the employees of company B. So company A says to company B's employees, bye-bye, so sorry, here's 2 weeks' pay. Thank you. Okay? And the other problem is with these long visa backlogs, an employee has an inability to advance, to change their job, to get promoted. Why? Because in the immigrant visa process, someone who applies for an immigrant visa through employment applies for a certain job and a certain job description and certain duties and certain requirements. If that person gets promoted, they're not doing the same job anymore. So their labor certification is no longer valid. So that becomes a potential problem. So advancement becomes a problem as well. Okay, there's a new requirement now, started October 1, under the BAHA, Buy American, Hire American. New requirement is that aliens also now who have a approved I-485, who are ready to get their employment-based green card, have to submit a Form 245J to show that they're still doing the work that they were originally hired for which the labor certification was issued. So can we not text while we're listening to my wonderful erudite scholarship? Okay. So they've got to file Form 245J. If you don't file Form 245J, you won't get that green card. I probably had one of the first employment-based interviews of this year ever at Cleveland because my client was interviewed October 2 of 2017 at 8:30 in the morning in Cleveland. Okay. Not only that, we've got to get the employer to also sign Form I-245J stipulating that yes, the employee is hired and yes, the employee is continuing to do the job that he or she originally received their labor certification for. So all those things have been put into place to quote-unquote safeguard the U.S. worker. In the past, we never even had interviews for employment-based immigration cases for green cards. Employment-based never had an interview. Family-based had an interview. Employment-based did not. Now they're interviewing both for family-based cases and for employment-based cases. So that's just more work, something that you need to be aware of. Okay. Exclusion from the USA. We've talked about people coming in. We've talked about immigrant visas. We've talked about non-immigrant visas. We've talked about problems with both the immigrant visa process and the family-based, employment-based process. Let's talk about exclusion. What's exclusion from the USA? Someone tell me. What's exclusion? Nicolette, what's exclusion? No, right now I'm just asking you what's exclusion. So tell me what exclusion might be. You're excluded from getting a visa. You're excluded from doing what, basically? Entering the USA, right? You're excluded. So even before you entered, you're deemed to be inadmissible. Okay, now sometimes you enter and then they find out things about you, and then you're inadmissible. Okay, but you shouldn't even have been here in the first place. But that's right, it's inadmissibility. So Section 212, as we saw in the INA, lists the grounds of inadmissibility and includes also some of the waivers that are available. So what are some of the grounds for inadmissible? Crimes including drug offenses, unauthorized entry to the USA, overstays, and public charge and national security. Now, you and I both know, because we went through Section 212, right? It's a long section, many pages, lots of grounds of inadmissibility. I've simply summarized these here. So these are some of the main bases for inadmissibility. Those are the bases, okay? Deportation from the USA. Now, that goes back to the question you asked me earlier, Nicolette. So what's deportation from the USA? What does deportation mean? Right. So deportation means you're here and we're going to send you back. Why? Because you may have done certain things. What are those certain things? They're codified under Immigration and Nationality Act, Section 237. Crimes, immigration law and or visa violations, or there's a public interest or national security issue. Now again, I've summarized that very briefly. As you know from the statute which we looked at, it goes on for several pages. So those are some of the key issues that people are placed in deportation proceedings. Now, both exclusion and deportation proceedings are together, lumped together, and they're called removal proceedings. Since IRA of 1996, both those processes, Section 212 as well as Section 237, have been lumped together. So if someone is in a process to be removed from the USA, whether it's exclusion, whether it's deportation, it's called a removal proceeding. Okay. Affidavit of support. We talked about that briefly earlier. A sponsorship through a family, or in very limited instances, a business, requires a Form I-864 to be filled out. That's the affidavit of support, which stipulates that the company or the petitioner has enough money to support the alien, and if the alien essentially becomes a public charge, takes public assistance, the US government can go after the petitioner or the company and recover that money from that company or that petitioner. Now, there are two exceptions. Number one, the alien himself or herself works for 40 qualifying quarters, which is equal to 10 years, works for 40 qualifying quarters, or becomes a US citizen. So once they become a US citizen and then they start taking everything they can from Uncle Sam, and you and I pay for it, okay, they're okay. They will not be deported. They will not become a public charge. Why? Because they are now a US citizen. The US government will not go back against the petitioner because the alien started taking benefits from the government only after they became a citizen. And that's naturally true, because if you're a citizen, you are entitled to equal protection, right? You're entitled to equal benefits as a citizen would be. Otherwise, you'd be a second-class citizen. Do we have second-class citizens in this country? We don't. Anyone who's a citizen gets the full rights of citizenship, okay? So there is, becoming a citizen is an absolute termination of the 864 affidavit of support. The affidavit of support is going to be valid for 10 years. So if the alien doesn't work 40 qualifying quarters or doesn't become a US citizen, even for 10 years, the affidavit of support is still enforceable against the petitioner. 10 years, that's a long time. Even if the petitioner, let's say, is a classic example, petitioner is a US citizen, gets married to an alien spouse. Alien spouse comes here, they get divorced. Is the USC petitioner still on the hook for the affidavit of support? Yes or no? Yes. Yes. Okay, good. Right, you're correct. Right? Even though a US citizen marries an alien spouse and they get divorced, the US citizen who filled out the affidavit of support is still on the hook for up to 10 years. In fact, now there's a trend where in domestic relations, if you do domestic relations and the alien spouse is your client, the attorneys are actually asking for the affidavit of support. Why? Because they're going up to domestic relations court and saying, look, the other party agreed to support my client for 10 years. And here's proof of his income. Because along with the affidavit of support, the petitioner also has to attach their proof of their employment or their bank account or whatever assets they have to document enough money to support the alien. And by doing that, they've actually created a nice dossier of information that the opposing attorney can then use in order to support his or her client's petition for spousal support or alimony or child support or what have you. Tricky, yep. So get married not only for love but also for money. Okay, immigration law. Let's switch gears now. We've talked about immigration, through family, we've talked about the affidavit of support, we've talked about non-immigrant and immigrant visa. Let's switch gears a little bit and go to some of the items we talked about with regard to exclusion and removal, which is convictions, because those are one of the main things that lead to someone being placed in removal proceedings. Conviction. So what's the definition of conviction? That's a definition under the Immigration and Nationality Act. We talked about it at length in court, remember? So what are the elements? A person has either been found guilty or has admitted to, that means they pled, okay, or has admitted to enough of the facts sufficient to warrant a finding of guilt, and a judge has imposed some form of punishment or restraint on liberty. So that's a conviction for immigration purposes. Yes? no. It's been around for a long, long time.
Was there a political reason for that definition?
I don't know. I really don't know the answer to that question. Why do you ask that question?
Because it's essentially saying if you're an immigrant, you can't use a diversion program, which
Correct.
seems to be bad
Well,
public policy.
I'll put it to you this way. There has been throughout history always scapegoating of different people, right? There's always scapegoating of criminals because they're easy to scapegoat. Then in the 90s, it began to be scapegoating of immigrants. So clearly, there's a reason. We're going to shut down every loophole possible for the immigrant not to get any benefit, and that would include putting them into a diversionary program. Okay. Well, a lot of laws we have on the books, even though they may not be for immigration, may still not make sense, right? But that's a very good question you've asked, and I truthfully don't know the reason behind having that diversionary program excluded from being, benefiting aliens for immigration proceedings. Yes?
What about no contest?
No contest is also there. No contest says no lo contendere. Right, okay? So no contest is also a conviction, because by pleading no contest, you have actually said, I'm not arguing with this. Basically, you're admitting to the facts without saying I'm guilty. That's all it means. So that's another problem. That's why as attorneys, when you're practicing immigration law or you're practicing, let's say, criminal law, someone comes to you and says, should we just plead guilty or should we just plead no contest? No. If they're not a citizen, there's a real problem. Okay. So what are some of the crimes that typically have immigration consequences? And we see them, I see a lot of these, so I'm relating them to you. These are the typical garden variety crimes that have immigration consequences. Domestic violence, violation of a temporary protective order, a DUI, child endangerment, identity fraud or identity theft, drug possession, drug use, drug trafficking. Yes?
In what context are you seeing child endangerment?
Because you have a child, let's say, who may be left in a car, or a child who may perhaps be in a situation where the child is not safe, or you've got a child who may be perhaps abused or is suspected of being abused by the alien. You've got all of those situations. So yes, you have child endangerment issues. So I had a situation where, and you will see this when you do bond proceedings, when you have a person driving a car, let's say, who does not have a driver's license and who doesn't carry insurance. Now they're stopped, let's say, by the local police. There's a child in the back seat. Okay, has the person committed potentially child endangerment? Someone may argue, yes, they have, because they are driving around uninsured and they're not even licensed. So there's a problem. Or they may have a child in the back seat who's not in a child seat. That's clearly child endangerment. Okay, so all those things kick into play. Now, DUI doesn't have a direct impact on immigration because there's no DUI related crime, but what will happen is this. If an alien is picked up, let's say, for a traffic offense, and that alien has any kind of immigration violation, maybe they're an overstay, maybe they entered without inspection, but they're picked up on a DUI, it is more likely than not that the immigration judge will not give you a bond because of that person's DUI history, recent DUI history. And they're not going to give you that bond, or they're going to set the bond extraordinarily high. If the DUI is far off in the past, there's a potential that you may get a bond. If there's no history of DUIs, you may get a bond. But a recent DUI, you'll not get a bond. Okay, crimes that are specific to immigration law. Inadmissible at time of entry or adjustment of status. So maybe you lied, you concealed something, and they didn't know and you're inadmissible. Present in violation of the law. So for example, you have overstayed your visa. You can't, you're not supposed to do that. Violation of the immigrant status or condition of entry. So you came in as an F1 student, and then instead of going to Akron you started working at some restaurant. Okay, and that's a violation of the terms of your status. Termination of conditional permanent residence. So let's say you're married to a U.S. citizen, you have a 2-year quote-unquote green card, you fail to file a joint application or a single application to remove the conditions on your permanent residency within the 2 years, you have now violated the terms of your conditional permanent residency. your card is expired, you may be removable because of that. Alien smuggling, of course, we know there's a special exemption in the case of family reunification. There's marriage fraud, and of course, in some cases, waivers may be authorized. We talked about waivers for a long time in another class. You remember that, right, everybody? Okay? All right. So before you admit a plea on behalf of a defendant in criminal court, because we're talking about criminal court and waivers and the definition of conviction, you must ascertain if your client is a U.S. citizen or not. Ascertain citizenship status before you enter a plea, not after. It's a little bit too late when it's all done. Okay? So in our state, in Ohio, ORC 2943.031 specifically says the court is to advise a defendant as to possible deportation, exclusion, or denial of naturalization upon guilty or a no contest plea. So the court is supposed to say, look, are you a citizen? You're not a citizen. You may be subject to deportation. You may be excluded from the USA, or you may be denied naturalization if you plead guilty. Do you understand that? If you plead no contest, you may result in these charges. Do you understand that? Okay. There's a Supreme Court case called Padilla versus Kentucky, where the attorney did not give enough of information to the client. Okay, that's different from the warning. In Ohio, we actually have a statutory warning. Okay, and if the statutory warning is not given, that's a basis in Ohio to reopen the criminal conviction and then potentially reduce it, or if the prosecutor is not willing to do that, they may retry the case, which may put your client in a worse posture. So you've got to evaluate, is it worthwhile to reopen the case and reduce the charge and reduce the conviction, or is it better to keep the case as it is, and then if there's a waiver available in immigration court, file the waiver instead? And of course, you can try both. You can approach the prosecutor, seek to reopen and reduce. If they say no, then you're stuck with going for the waiver. All right? So those are, you've got to decide what your strategy is going to be. But Padilla versus Kentucky essentially was an ineffective assistance of counsel case. And then Padilla was modified somewhat by U.S. versus Chaidez. In U.S. versus Chaidez, the Supreme Court said, look, Padilla versus Kentucky created a new rule. Because it created a new rule, it cannot be retroactive. So any conviction that came after March 31st of 2010 is affected by Padilla and ineffective assistance of counsel. But any conviction that was before that date is not going to be considered under Padilla. So counsel did not render ineffective assistance by failing to tell them of the immigration consequences of their criminal conviction. All right, so withdrawing a guilty plea. There must be an underlying issue of law or fact or a constitutional issue that permits the withdrawal of a guilty plea. If a plea is withdrawn purely for immigration purposes, it may still count as a conviction for removal or exclusion. So when you're practicing criminal law and you go up to the court with a motion to withdraw the plea, don't say in your motion, we want to withdraw the plea because my client will suffer deportation. Because the only reason to withdraw the plea is immigration consequences. From the immigration standpoint, that plea is still a conviction and will lead to deportation. So all your work and all the money your client has paid you is going to go up in smoke because it's worthless. You've got to find a factual basis, a constitutional basis, a procedural infirmity in order to defend your client and get the plea vacated. So here's what we have. A conviction vacated for rehabilitative or immigration reasons remains valid. It's still a conviction, while a conviction vacated for substantive or procedural infirmities does not have any immigration consequence. And that's our leading case in our circuit, Barakat versus Holder. Okay, crimes with immigration consequences. So crimes with immigration consequences are crimes involving moral turpitude. There's two elements: commission within 5 years of the date of admission, and a sentence of 1 year or more may be imposed. May be imposed, not is imposed. So if a sentence of 1 year or more may be imposed, even though the defendant got 6 months, but the maximum could have been 13 months, it's still a conviction for immigration purposes under a crime involving moral turpitude. And then multiple criminal convictions. 2 or more crimes involving moral turpitude, not arising out of a single scheme of criminal misconduct, and the length of the sentence is immaterial. So that's a really, really sad one, because you've got people who are going to be convicted, let's say, of multiple counts of shoplifting. So the first count was a small count, they picked up one thing, maybe 6 months later, they picked up something else. So the first count would have been under the first bulleted item. And that's only one crime, but the maximum sentence was 30 days, so it's not a deportable offense. Okay? But now they've got a second count. They fall into the second bulleted item. Multiple criminal convictions not arising out of the same scheme of criminal misconduct, and the length of the sentence is immaterial. So even if it was 30 days on both times, reduced to nothing, slap on the wrist, probation, they've still committed 2 or more crimes involving moral turpitude. What does that make them? Deportable. So 2 minor offenses can ruin a person's life. 2 minor offenses. Nicolette, you look like you're brimming with questions. Louder, a little bit louder. That's if they commit only one crime, correct.
So the immigrant was here for 6 years, and that's when they committed the 6 year.
Doesn't count. Doesn't count. But if they commit a second crime, then there's no limitation on when it's committed.
Well, the one committed in year 60, that's what they're trying to get, like, citizenship or green card.
No, because it's not a removable offense. But if they file for citizenship within 5 years of having committed that crime, will that be used against them? Yes or no? You're on recording, so say yes, yes, correct. Why? Because what's the statutory period within which USCIS must go back and look at someone's good moral character for purposes of citizenship? What's the statutory period, Megan? 5 years, exactly. So your advice to your client who's looking for citizenship is, if you've had certain crimes within the 5 years before you apply for citizenship, then either let's fix it or don't do it. Wait for the 5 years. What's the other reason we don't apply for citizenship if you have a potential, if you have a criminal record? What's the other reason? Why else would you not apply for citizenship? Let's say your client comes to you, he's committed aggravated burglary 10 years ago. He says, you know what, that was 10 years ago, I went to jail, I did my time, and I want to become a citizen now. What are you going to tell that client? Let's go ahead and apply for citizenship? Serena, you're shaking your head no. Sarah, you're shaking your head no. Who else says no? Nicolette says no. Megan says no. You said no to Janet? Okay. Kimberly is out there. You said no too? No. No. Very good. Why would you say no? Kimberly, why would you say no? Potentially, yes. Because an aggravated burglary may fall into the USCIS definition of what is an aggravated felony. And if that's an aggravated felony, then yes, they are not only subject to mandatory detention, they're subject to being placed in removal proceedings. Okay? So you've got a problem. So you've got to be very sure to advise your client, tell me everything before we apply for naturalization. Okay, let's move on. Okay, some other crimes. Aggravated felonies, high-speed flight from a U.S. immigration checkpoint, failure to register as a sex offender, controlled substance violations. What's the only exception? Yep. For how many times can you have, can you be busted for that more than once, twice, 3 times, a dozen times? How many times? Only once. You get one chance, okay? You get one bite of the apple, you get one puff of the joint. That's it. Okay? That's 30 grams or less of marijuana. Okay. Other crimes, firearms offenses, crimes of domestic violence, stalking, violation of protective order, crimes against children. We talked about that a little while ago. Human trafficking, failure to register, false claim to U.S. citizenship, national security, etc., persecution of others, voting or registration to vote. We talked about that in the last class, you may remember, and a public charge. We've talked about that as well quite extensively. Some of the recent immigration cases are INS versus St. Cyr, which said 212C relief still exists for convictions that were entered into prior to April 30th of 1997. Padilla versus Kentucky, we just talked about that. Chidas versus U.S. Judulang versus Holder, which essentially said the grounds of exclusion are equivalent to the grounds of removal under Section 237, and therefore you don't have to have an exact match between the two in order to qualify for certain kinds of relief. Moncrief versus Holder is a recent case that just came out. I mean, recent, but they haven't completed the site yet, that talked about drug possession and saying that drug possession is not simply equivalent to drug trafficking. Even if you have the marijuana, let's say, in your possession, and you're simply sharing it with someone, does not mean you are a drug trafficker. So that helped, obviously, Mr. Moncrief quite a lot. That's a new case that came out. We have a new case pending right now which talks about essentially mandatory detention and the ability of people to be released from it, Rodriguez versus Jennings. That's going to be heard, I think it's already been heard in the Supreme Court, and they're going to render a decision pretty soon. Yes, Jeanette?
For cases like that go in front of the Supreme Court, like they want to try and cert in front of the Supreme Court, how much discretion or how involved would the Attorney General be? Because I'm kind of surprised to see like Eric Holder. Like how I guess what I'm saying is how much does the politics of the administration fall down in line with the policies of the agencies? Like you would think that the Obama administration would tell like the Department of Justice to be more lax on their immigration enforcement.
Yeah, but don't forget that the government may perhaps have a philosophy of immigration, but it's not going to also be totally lax and say we are not going to defend this, or we're not going to want to get bad people out of the country. I mean, they have an obligation to uphold the Constitution. Okay, so for example, a great example of this was where the Attorney General in Obama's time said that we are not going to defend DOMA, the Defense of Marriage Act. We're not going to defend that act because it was so blatantly skewed against gay marriage, for example. Okay, and we're not going to defend it in the Supreme Court if it comes to that. So the Attorney General actually said we're not going to do this. And so that sometimes you see that kind of policy decision being made, but by and large, you're not going to see that happening, especially if there's a split between the circuits, as it was in Moncrief as well. So you're not going to see that. They're going to defend it, or whatever it might be. But most of the time, you're going to see them trying to uphold the law and order type situation. Okay? All right. DUI, it's a federal case. It's a negative factor for bond, as we said, especially if there's a history of DUIs or recent DUI. There are some resources available. There's no bond by ICE, and immigration judges are reluctant to grant release on bond. Why? Because the guy gets out, has another DUI, goes and kills someone else. Whose fault is that? The judge's fault, right? Because the judge let them out. So you do have a problem with DUIs, very serious problem. Very difficult to defend in immigration court, especially if the prior case has already concluded. So if the DUI is already over, there's no way to go back. It's going to be very hard to reopen it. The physical evidence that's against your client is going to be very hard. The only way, hopefully, is if the client hasn't completed the DUI case, you could go back, maybe discuss with the prosecutor, get the client into some kind of a rehab treatment or whatever, and then, God forbid, ICE picks him up. At least he's got some good basis to say, look, I am not an alcoholic, I am going for treatment, and this isn't a DUI, it was reduced to something else. Potential, okay, so you've got that. But a DUI is still not a removable offense. So if someone who's a permanent resident gets arrested on a DUI, it's not a removable offense. Keep that in mind. Okay, that's not a good thing necessarily if they have a string of DUIs, but it's not a removable offense. Okay. Fiancé visa, we talked a lot about that. Let's go through the process a little bit, because this is something that you might see in your practice doing immigration law, as we discussed, at least 200 miles away from Akron. Right? Okay? So there's actual face-to-face visit within the last 2 years. You file the form. On approval of the form, you file documents with the National Visa Center. There's consular processing. They've got to be in an overseas country. They process their visa at the U.S. consulate in that country. They're allowed to enter the USA. The entry is valid for 90 days. They must get married within the 90 days. If they don't get married within the 90 days, that fiancé visa essentially is terminated, and they've got to go home. Otherwise, their status has expired. They violated the terms of their status, and they would be placed in removal proceedings. And they must file for adjustment of status. That's the green card after the marriage. So just because they're married doesn't automatically mean that the alien spouse who entered on an F1 is going to get a green card. He or she has to apply for the green card. Someone had a hand up somewhere. Yes? No.
So how, where in the,
This comes into play only if the person is overseas and their spouse-to-be is in the U.S.
so if they're both here and they want to change from, say, a B2 to a K1, they just would file for an adjustment of status?
They would file a family-based petition first, which is the Form I-130, and then they would file for adjustment of status. They can file those concurrently.
Do they need to get the K, or could they just?
No, they don't need to get the K because the person's already here. The K is only the visa to allow the person to get here. So some countries have some people in some countries have a very hard time getting a K visa or any visa for that matter. For example, not K, forgive me, a B visa, a visitor visa for that matter. And so I'll give you an example. If you have a young woman from Thailand who's single, wants to come to this country, most likely she's not going to get a B1, B2 tourist visa because they're going to say to her, you're going to go to the US, you're going to meet someone, you're going to get married, and you're going to come back. Or you're going to go to the US, you're going to overstay your visa, you're going to start working, and you're going to come back. Same thing for nationals from other countries. Okay? So then the US citizen has no option but to seek a K1 fiancé visa, and if they've got all the necessary proof of the relationship, the alien will go to the consulate in, let's say, Bangkok, in our example, obtain the K1 fiancé visa, come to the USA, 90 days, get married, boom, apply for the green card. Okay? Conditional LPR. So, conditional permanent residence was imposed by the Immigration Marriage Fraud Amendments of 1986 because, as I may have told you, aliens were getting married to US citizens. Sometimes there was some exchange involved, and then after they got their green card, the alien would say, hasta la vista, baby. Okay? And then after saying hasta la vista, they went on their own way. The government got upset about it. So in 1986, with the Immigration Marriage Fraud Amendments, they said, we are going to give a green card to the alien, but it's going to be a conditional green card. It's going to be good for only 2 years. Before that 2 years ends, both the alien spouse and the US citizen spouse must file a joint application with proof of their life together for the last 2 years. And then we'll approve the unconditional or the permanent green card. So that's what the IMFA says. Now, there is an exception. So if someone had a good faith marriage, but the marriage broke down within 2 years, which could happen, there's a provision in the law that says, okay, even a single conditional permanent resident can still apply for removal of conditions, but then they've got to have proof, essentially, that the marriage they entered into was in good faith. And that can be hard to prove sometimes. It can be easy to prove. Okay? So, and conditional legal permanent resident status is also imposed for EB-5 investor visa cases. So if there's an investor visa, that person is going to get a conditional residence because they have to show that they're creating these jobs. And creating the jobs takes time, so they've got to prove over time they've created the jobs, and then they get their green card. Asylum and refugee law. Let's switch gears a little bit. Yes, before we switch gears, go ahead, Nicolette.
This goes back to the affidavit of support. In a situation where they're married, spouse says that does the affidavit of support and say, can that be a situation where then they kind of like can get out of that?
That's a great question. I would say to you it probably would be hard for them to get out of it, to have the US government actually allow them to revoke it. But I think it's going to be very hard for the US government to collect anything based on that affidavit given those facts. Because they'd almost have to go back to court to collect it, to enforce the affidavit, to have some kind of a, let's say if the US citizen spouse is working and they've got to garnish their wages. They can't just go to the employer and garnish wages. They've got to get a judgment against the US citizen. To get a judgment, they've got to go to court. And in court, the US citizen could defend themselves and say, hey, this are the circumstances. This was never something that I envisaged. Why should I be on the hook for someone who essentially battered me or my children? And, you know, fight that affidavit of support. So I think there may be some legal basis to challenge it in court. Okay? Yes, Ms. Jeanette.
If the US citizen spouse has like passed away, can family members do affidavits of support?
Yes. Yes, they can. In fact, as I said earlier, there are humanitarian bases for continuing an application for immigrant visa even if a beneficiary has died. And if that is the case, then certainly the family members can come in and do an affidavit. Many a time, the petitioner may not even be making enough money. And so they file an affidavit of support, and along with that, they find a co-sponsor who's making enough to fill in the difference that the petitioner doesn't have. And that difference can be filled in by a co-sponsor filing a separate affidavit of support. Okay? So they'd file an affidavit of support as well. So we good with all that so far? Everyone on the same page? Yes? Okay. So asylum and refugee law. Let's switch gears a little bit. We talked a lot about it in the past. We're going to have your client come in that you're going to be interviewing in a couple of weeks about their asylum case. So this is a very important topic, not only for you as lawyers, but also for the purpose of this class. So what's asylum and refugee law? You establish past persecution or a well-founded fear of future persecution. What are the 5 protected groups? On the basis of race, religion, membership in a particular social group, and you've got to read the cases, MEVG and WGR. Those define what a particular social group is, nationality or political opinion. So take a look at those cases and read them in order to prepare your asylum case that's going to be your final assignment. Asylum and refugee law, continued. There must be a nexus or a connection between one or more of the 5 protected groups and the persecution of the asylum seeker, because asylum is given to someone who's being persecuted or has a well-founded fear of future persecution based on account of their membership in one of those groups. The PSG cannot be framed in terms of the persecution that's inflicted. So you cannot say women in Guatemala who are battered by their partners, because you're framing the persecution, framing the social group in terms of the persecution. What you have to say, as is defined in case law, is women in Guatemala who are in an abusive relationship and are unable to leave that relationship. So they're not being defined in terms of their persecution, they're being defined in terms of their status as a person who cannot leave a relationship. Okay, different standards for grant of asylum, withholding of removal, and CAT. So in asylum, as you know, the standard is very low. Even if you can show a 10% chance of being persecuted, or you've been persecuted before and this is a 10% chance of future persecution, you could be granted asylum. With withholding of removal, you must show that it's more likely than not, meaning it's 51%, 50% or more that you will be persecuted. So it's got to be 50.01% that you will be persecuted, more likely than not that you will be persecuted. For CAT relief, there is no such requirement. What you have to show is that you will be tortured if you're returned to your home country. And it doesn't have to be torture on the basis of one of those 5 groups. It can be torture on the basis of anything, as long as the torture is inflicted by the government or by groups that the government has control of or willfully chooses not to control. So that is CAT relief. So it's possible to get relief even without being a member of one of those 5 groups if you qualify for CAT. However, for both removal, withholding of removal, and for CAT relief, both of those statuses may be revoked by the government. So if country conditions change in the home country, the government may choose to revoke withholding, or it may choose to revoke CAT relief. Also, if a person has a criminal record, or criminal record will go against an application for asylum if it's sufficiently serious. However, despite a person's criminal record, a judge must grant withholding unless it's for a particularly serious crime. So minor criminal issues will not affect a person's grant of withholding of removal, but minor criminal issues in the aggregate could affect a grant of asylum. Okay. Temporary relief from removal. So sometimes you don't get you may not have a basis for an asylum claim, but there may be temporary protected status for a short time because of a civil war or an earthquake or some other calamity in the home country. So in that case, the US government says, we don't think it's safe for people to go back. We want to allow people to stay here. We want to keep them here until conditions improve in their home country. Deferred action, meaning we're not going to deport a certain class of alien we have decided we're not going to send any of these people back home for now. We're going to defer any action on them. Deferring means, of course, we're not going to do anything. We're going to let them stay. And one good example right now was DACA. What is DACA? We talked about it. What's DACA? For childhood arrivals. So for the young, for the dreamers. Okay, so that's called DACA, deferred action for childhood arrivals. So that is an example of deferred action. Prosecutorial discretion. Prosecutorial discretion was big during the Obama years. Essentially what it says was, in order to conserve the resources of the DHS prosecutors, we're not going to prosecute every case that comes our way. Cases that can be administratively closed, that are for offenses that are very minor, for example, simply illegal entry, no criminal history, we're going to close those cases. We're not going to prosecute them at this point in time. Now, there's no prosecutorial discretion. In fact, DHS is actively looking at all the admin closed cases that were filed during the Obama years, and is reopening those cases to recalendar them for court hearings. So that's what's happening with prosecutorial discretion. There's withholding of removal, and we talked about that. I say it's temporary. Why is it temporary? Because it can be declined by the government if conditions change. There's orders of supervision, which means even without a removal proceeding, if a person has entered into, let's say, an agreement with the government that yes, they can be removed from the USA, but the government decides that they can stay here for a while, maybe they have a family, they have children, whatever, and this person's cooperating with the government can give them an order of supervision, which means you'll be allowed to stay here at our discretion, provided you comply with these requirements, which might be come and report to us every month, okay, call in once a week, whatever those requirements might be, they're placed on an order of supervision. And then finally, there's voluntary departure. And again, I put that into temporary relief from removal because you can make an agreement with the government, let's say, to depart voluntarily, and they may allow you to be free, settle your affairs, come back with a plane ticket by a certain date, and then you leave the country. So that's still, in a sense, temporary relief from removal. You're not being handcuffed and detained and put on a plane at the government's timetable. You're choosing to leave on your own timetable. All right. Other forms of relief. We talked about cancellation of removal. Do you remember we read the Racines case, right? And the Zola case, okay, matter of Montreal. Cancellation of removal for both LPRs, and we need 7 years in this country, at least 5 years as a permanent resident, and no aggravated felony. For non-LPRs, we need at least 10 years in this country, and we have to show not only extreme hardship, but extreme and exceptionally unusual hardship, right? That's why I have the little abbreviation there, extreme plus hardship. Not just extreme hardship, but exceptional and extremely unusual hardship. That's the standard for cancellation of removal for non-LPRs, people who don't have green cards. Immigrant visa petition, either a family or an employment-based petition, may become current and may allow the person to adjust their status. You have grandfathered Life Act cases. For those, I mean, this is really going back in time, but these are cases that were filed on or before April 30th of 2001, because the Life Act was actually signed into law by President Bill Clinton, okay? And those cases may, because of the priority date backlogs, even now be trickling through the system. So if someone has a grandfathered case or has a new case and had an old case filed as a Life Act case, they can piggyback their new case on the old Life Act case, and they can get their adjustment of status. And finally, the I-601 or the I-601A waiver. For the I-601A waiver or the 601, the alien must leave the USA, go to their home country, get to the consulate, be processed for the waiver, either at the consulate or at the USCIS, attend the interview at the consulate, and then return back to the USA. So that is the I-601 or 601A waiver. Now keep in mind, class, this is all very, very broad, okay? I told you this in class 1. We cannot cover every aspect of immigration in this class, and that's not my intention. I'm simply trying to give you a broad overview, as broad as possible, so you at least have these terms, you have these tools, you have this knowledge, so when you go out there, someone talks to you, you know a little bit of what you're talking. But do not, I'm putting this on the record, do not dabble in immigration, please. Don't dabble in immigration. It's it's bad for not only for yourself, but more importantly, it's bad for your client, because you could really mess up somebody's life pretty badly if you're dabbling in something you don't know in immigration. It could really affect them. All right, what are some of the other forms of relief? Battered spouse or child petitions on Form I-360, the I-751 removal of conditions, the S visa, the T visa, the U visa, and then humanitarian asylum. That's for someone who may not even fit within one of the 5 grounds, but they've just been treated so horribly, horribly badly in the past that they qualify for humanitarian asylum. Okay, family-based immigration, we talked about that. Their immigrant visas, their limited number, their immediate relatives who are not limited. There are tiers of preference categories. We know that, right? Okay, so we know there are tiers of preference categories. Age and marital status are determining factors, as you told me earlier. A child becomes an adult at what age? 21. People who are married, as you know, with the preference category, are treated very different from people who are not married, right? Even if they are over 21. They may both be over 21, but one who's married goes to the bottom of the pile, one who's not married gets a lot higher. Okay, and there's limited protection against aging out under the Child Status Protection Act. So Child Status Protection Act says even if someone turned 21, we will subtract from their age the amount of time it took for USCIS to process their applications. And if that subtraction puts their age below 21, they're still considered to be a child. You see, I just finished a successful case for immigration where the clients had 2 children who had both aged out. But because USCIS took so long to process the underlying I-130 petition, we subtracted that amount of time from the amount of time that from the ages of the children, and it brought them back to below 21 as of the date the petitions, the priority date became current. So they still remain children. And because they remain children, we were able to file their petitions for them to emigrate along with their family. Otherwise, their family would have come first, and then they would have had to apply for their children who had aged out. So the Child Status Protection Act can be your friend, can be your very, very good friend, indeed. So keep that in mind. Yes, Nicolette?
I've been thinking of this wrong. Is it 21 and older years old? So child is 20 and younger. It doesn't include.
No, it includes all the dates all the way up till you turn 21.
So even if I'm
You can be 20 years and 364 days, you're still a child.
okay, so once you hit 21.
Correct.
Okay, so
Correct. In fact, I had that happen with a client of mine many years ago who was on a J1 visa, and we successfully petitioned for and got a waiver. And in those days, you could actually go and talk to someone at immigration and get things moving. And I actually trotted up to Cleveland with my client and the child, who would have turned 21, I think like in the next 3 days or something. And USCIS in Cleveland contacted the J1 waiver office in Washington, D.C. They worked out that the waiver was granted. They were then able to adjust the status of this child before the child turned 21. But that was before CSPA, you see? But that's how important it is to be able to file and move things along. Because had I not done that, that child would have never received their green card at the same time. They might have been waiting for another 5 years more based on the backlogs for visas filed by permanent residents for their children. Okay, so those are the things that you've got to keep in mind. Employment-based immigration. So there's a limited annual quota per the statute. The first 3 preferences are based on educational level, complexity of the work, and international recognition or a claim. The 4th preference is sort of a catch-all, includes religious workers, includes special immigrant juveniles, includes other special immigrants. And the 5th preference, as we know, is for employment creation through investment. Then, what's the green card? You file for a green card using Form I-485. Now, you remember this in class, right? We went through the green card application. We went through the I-485 page by page, question by question. Remember that? Yep. Have you committed this crime? Have you done this? Have you done that? Okay, all those questions. Pages and pages of questions. All right. Must have underlying petition approved. So it can't just file a 485. You must have something underneath it. For example, in case of the fiancé, that was your question. The fiancé enters, gets married. Only after the fiancé is married can he or she apply for the green card. Okay, so the underlying petition in this case, the K-1 was approved, they came into this country, and because the K-1 was approved and the marriage took place, they're entitled to apply for a green card. Had the marriage not taken place, they obviously couldn't have gotten a green card. Someone is an employee and he or she has an H-1B visa. Having the H-1B is not going to give you a green card, because the H-1B is simply a non-immigrant visa. They've got to have an underlying immigrant visa petition approved for them. So the employer has to go through the process called labor certification, and thereafter apply for the Form I-140, and thereafter, once the Form I-140 is approved, either the priority date is current and they can apply for adjustment of status, or they've got to wait for whatever time it takes for the priority date to become current and then apply for the I-45. So the form is extensive and long. There's many questions on exclusions or grounds of deportation. Must have the underlying petition approved. Okay, U.S. citizenship. We talked about that in the last class. Obtaining citizenship either by birth to a U.S. citizen anywhere in the world, or by location in the United States, you're automatically a U.S. citizen, or by naturalization. And that's the last step in the immigrant visa saga for most immigrants. So what is naturalization? What's naturalization, class? No, N-400 is not naturalization. What is naturalization? N-400 is simply the vehicle to seek naturalization. What is naturalization? Becoming a citizen through a petition filed with the U.S. government saying, okay, I want to become a U.S. citizen. And how many years typically must you be a permanent resident in order to apply for naturalization? 5 years, correct. If you're married to a U.S. citizen, how many years? 3 years. It's shortened to 3 years, okay? What are some of the other requirements for becoming a naturalized U.S. citizen? Some of the other requirements. Good moral character, very good. What else? Let's see, Nicolette, what else? Megan, what else? Very good. Physical presence in the USA. Very good. Excellent. Okay. Jeanette. Correct. You cannot leave for over, unless you have you're working for a U.S. government employee, etc. Okay. So you can preserve your residency. Yes. Very good. You cannot leave for more than 1 year. Otherwise, it sets back the clock. Very good. What else? Any other requirements? For up to 3 months before you file the application. Correct. What else? What else? Be at least? Okay. Okay. What else? What else? Well, but you already had your green card, okay? So, I mean, let's assume that you don't have any of those other things. What else? What else? Serena, what else? How about, like, what you're doing right now? No, I'm not removing anyone from this class. What else? What are you doing right now with that screen of yours? Everybody. So what else do you need to know? Do you need to know how to read, write, and exactly, and pass the test? So you have to show your knowledge of English and also your knowledge of history and civics of the U.S., right? Correct? So those are some of the requirements for naturalization. Okay. Are there any exemptions from these requirements? If you're old, pretty much, yeah. If you're old and you've had your green card for a certain number of years, yes, there are certain exemptions, okay, for some of these requirements. Okay, let's talk about this. What are some of the pitfalls and some of the benefits for the applicant for naturalization? Some of the pitfalls. What's some of the dangers in naturalization? Someone comes to you and says, look, I want to become a U.S. citizen. What are you going to ask them about? Exactly. So not only will your application be denied, you'll also be potentially placed in removal proceedings. Okay. What are some of the benefits for someone to become a citizen? Yes, Jeanette?
Taxes.
Okay. Okay, work for the government. Okay, all right. It's really more of an estate tax thing, because it's pretty much the same taxes for permanent resident and for citizen, but more of an estate tax. If you die, then there's a bigger exemption for a citizen than there is for a permanent resident. Okay, so for someone at the big estate, all of your clients, of course, will have, God willing, big estates and bigger bank accounts. They can write you nice checks when they come to see you, right? Okay, splendid, excellent, that's the plan. Splendid, I'm glad to hear that. Okay, so US government jobs, tax benefits, what else? Voting, very good, absolutely. What else? What else? Well, you can only do school for permanent resident. What else? What else? What else? What else? Bring family over. Very good. That's right. We're in immigration law class. Yep. So, as you know, certain categories are hopelessly backlogged. But they're not backlogged, for example, for US citizens. And is there a category anywhere for parent other than as a parent of a US citizen? There isn't. So if you're a permanent resident, you want to bring your mom or dad over, can you bring them over till you become a citizen? No. You have to become a citizen because there's no category in the preferences for a parent of a permanent resident. Right? There's brothers and sisters, there's unmarried sons or daughters, there's married sons or daughters. There's no category for parent. So you have to be a US citizen to bring a parent over. All right. Okay. Naturalization. Can citizenship through birth be lost? Can someone commit an expatriating act and lose their citizenship through birth? Yes. No. What? We have one timid yeah. You're saying no.
If you're born here, you
Can't lose it. You can give it away. What else can you do to lose it? We looked at it last time in class. This is just a week ago. Should be fresh in your memory. Take up arms against the US at a time of conflict.
Does the time of conflict have to be declared by Congress?
I'm sure there has to be some defined period of time, some status of hostilities, absolutely, both to start and to finish. Okay. What else? What else can you, how else can you potentially lose your US citizenship? Well, it's not automatic to do that, but also you have to be elected as an official there or serve in their government or whatever, right? So there's some reasons, but so people who are born US citizens can still lose US citizenship. Okay, can citizenship through naturalization be lost or revoked? So in addition to all those reasons for someone losing their citizenship if they're born in the USA, it can also be revoked for something else, right? And what is that something else? A material misrepresentation in the course of becoming a US citizen, all right? Child Citizenship Act, we talked about that very briefly, and the Child Citizenship Act essentially protects children whose parents who become US citizens before the child turns 18. If the parent becomes a US citizen, the child is not a citizen, the child can simply petition for a certificate of citizenship, and that will give them automatic citizenship, which is very, very helpful because you don't want someone out there who's a parent, who's a citizen now, and they've forgotten to do anything for their child, and the next thing you know, the child commits a removable offense, and they can be deported because they're still a permanent resident. And that's happened to people. That has happened. Yes? Okay. Mm-hmm.
Then parents go get citizenship.
Yeah.
Are they going to look at any, like it's 3 years after that offense, are they going to look at that child?
No.
Okay.
No. Generally speaking, no, because it's a juvenile offense. Typically, it won't even show up in the person's record. So, no. Okay. And derivative citizenship. I gave you an extensive chart last time, several pages long. Derivative citizenship based on all of those different times and dates a child was born, whether born to a father, born to a mother, residency requirements of the parents to devolve citizenship on their children. You remember all that, right? So if someone comes to you and has an obscure question, you've got a resource, you look at that chart, and you can guide them as to when and how they might perhaps be a US citizen. Okay. There's a new DHS policy now. It's the executive order called BAHA. Okay, so BAHA humbug is the order. So what does BAHA say? BAHA says it essentially affects all aspects of US immigration because what it says is that the US government is number one going to buy American and hire American. Not only that, but then all the agencies of the US government are going to look at their own rules and policies and procedures with a view to protecting the US worker, increasing the wages for the middle class, and keeping essentially the foreign worker from taking away US jobs. It also has a second clause to it under Section 5, which says that it's specifically going to be aimed at disallowing the entry of foreign workers under the H-1B program who are getting paid low wages. So the first tier of H-1B workers or level 1 wages are specifically almost going to be extremely scrutinized under the Baha order. Now, because of the Baha order, we've seen in the immigration bar, as a practice pointer, a huge increase in the number of requests for evidence on H-1B cases in which the prevailing wage is the entry-level wage. So they're discouraging employers from filing H-1B applications for the entry-level wage, even though the employer may not be able to find a US worker or requires the foreign worker specifically because of the nature of their business. So that is having a real chilling effect when it's coupled with other executive orders on immigration. There's a culture of no right now at the USCIS, culture of no at the USICE, culture of no at the USCBP. Bars are set higher and higher, and the intent is to always deny. The intent is not to approve. You've got to fill in, and backfill in order to get a visa approval. And if you don't meet those increasingly high requirements imposed by the request for evidence, you're most likely going to be denied on a small technicality, and then your case will be out. And then you go to appeal it at the Administrative Appeals Office. That takes us into the last part, administrative and judicial review. So every agency has its own administrative review tribunal. For example, the EOIR, or the Executive Office for Immigration Review, has the Board of Immigration Appeals. The DOL has BALCA. The USCIS has the Administrative Appeals Unit or Administrative Appeals Office. Then decisions from these bodies can themselves be appealed to the US District or the Appeals Court. So they themselves, there's another level of appeal as well to the US District Court or the Appeals Court. Okay. The US District Court has original jurisdiction in certain petitions. For example, habeas petitions, challenges to detention. There's a current case pending in the US Supreme Court called Rodriguez v. Jennings. IRA tried to strip the US District Courts and the Appeals Courts of jurisdiction, and it failed. And finally, there's injunctive relief as well. So, for example, in the Ninth Circuit has held that immigration judges must consider the ability of an alien to pay a bond when they're issuing a bond for a detained alien. So unfortunately, that's only in the Ninth Circuit, but it's overall for the entire Ninth Circuit, which encompasses, as you know, the most states of any circuit in the country. So we move from that into removal cases. What's the anatomy of a typical removal case? So you get a notice to appear in immigration court. We looked at one last time. Do you remember? I showed you a notice to appear for someone who had committed a crime. Do you remember that? Okay, so that's a notice to appear. You have a master hearing, which is the first hearing typically in immigration court. You may have more than one master hearing to file petitions, to discuss applications, to discuss the status of a case, to discuss what the US government has decided to do, etc. You may have a merits hearing or an individual hearing, and that means you also bring in at that point in time your witnesses, your testimony, any experts, and also file for any waivers that your client may be eligible for. You have a decision. Either party or both parties may appeal the decision to the Board of Immigration Appeals. If the BIA decides against the respondent or the alien, then the alien can appeal to the appeals court for the particular circuit where the case arose. Very interestingly, if the BIA rules against the government can't appeal to the appeals court. But if the BIA rules against the respondent can appeal to the appeals court. Okay, appeal from a USCIS decision. If the USCIS says no on a family-based case, for example, you appeal to the BIA. However, if the USCIS says no on an employment-based case, you appeal to the AAO. So there's two different appellate bodies for the USCIS. If the naturalization application is not decided within 120 days of a person's interview at the USCIS, that person can petition the US District Court for a decision on the naturalization application. So they can bypass USCIS altogether. Resources. This is where we start wrapping things up. So many people are already using Kurzban's Immigration Law Sourcebook. That's an invaluable resource. Immigration Law and Defense, that's a series published by AILA. U.S. Immigration, Step by Step. Also consider using the website of the American Immigration Law Foundation, and you see the website link there. And join AILA. AILA is a wonderful group. It especially has a significant discount for student members. And as I understand it, if you're a student member, you can also get onto their incredible resource called AILA Link, which has a lot of publications online for free. So it's a very, very wonderful resource to join AILA if you are a student. For a very nominal fee, you'll get access to what we as immigration lawyers are probably paying almost $1,200 to $1,500 a year for. You might get it for like $50 or $100. Okay. Some other resources. USCIS.gov is a wonderful resource for your latest up-to-the-minute forms, filing information, fee information. Very important to consult this before you file anything, so you don't file the wrong form or the wrong version with the wrong fee at the wrong address and look like you're completely incompetent. All right? Check the website. State.gov gives you your visa bulletins, country condition reports, and important diplomatic and visa news. Other blog pages, including mine. Look at my LinkedIn page as well, because I post new articles on there, and I sometimes post videos on my YouTube channel, so you can look at some of those. Now I'd like to wrap it up and give you a chance to ask questions and hopefully give you some answers. So anyone have any questions? Hello, hello, hello. Hello. Good. All right. Anyone have a question? Question? We'll have to ask questions. Question, anybody? Nope? Okay. Yes, we have a question here from row number 2. It is Miss Nicolette. Well, take the mic then, no?
I have a question about federal preemptiveness, because Arizona v. United States, where they said the laws the state was using to essentially
dabble in immigration.
Right. Okay. So, I mean, what laws can states do that aren't preempted by the federal government?
Well, that's a great example. Most of the laws that a state might propose and pass on immigration are going to be trying to preempt federal law, and that's not going to be allowed. Why? Because the federal government is the only authority in the USA with plenary power over immigration. So states, as you know, states can enact laws relating to crime and enact laws related to family matters and to estates and things like that, right? Okay. But the federal government is the only entity in the USA that's allowed to enact laws on immigration. Also, are states allowed to enact laws on national defense? No, they're not, right? For good reason, right? Because we want to have protection in a unified manner. Same way we want to protect our borders in a unified fashion. We don't want 50 states having 50 different immigration policies. Correct? Okay? So that's why you have only the federal government being allowed to do that. So if states try to get into the act, the Supreme Court is most likely going to strike them down and then say unconstitutional.
But I was confused because your slide said that state and local governments can...
Yes, they can, because what they can do is they can enact laws that make it harder for people to get citizenship. They can make certain offenses much more difficult to, or they can make certain offenses essentially amenable to deportation. They can make things harder for aliens if they want to, or they can make things easier for aliens as well. For example, here's a classic example. If someone is convicted of a certain crime and their crime carries a sentence of 1 year or more, it may potentially become an aggravated felony. Okay? All right? If the state says we are going to reduce all the sentences for that particular crime to 364 days or less, they've just taken out the aggravated felony component from that crime. Now, if the alien has more than one crime and it's a crime involving moral turpitude, they've still got a problem. but the state has now enacted a law that has immigration consequences. And California just did this earlier this year. Okay, they've enacted a law that says essentially if you have a conviction for a crime and the sentence is more than 1 year for certain types of crimes, you can appeal to the state to reopen that case, and the state has the right and the ability to reduce the sentence to 364 days or less. So that benefits someone who may be in removal proceedings. So do you see how that works?
Is that law only for immigrants or for everybody?
For everybody, because it would be unfair to have that only for someone who's an immigrant and someone who's not have a blot on their career, let's say as a felony. It wouldn't be fair, and that would be challenged, right?
Okay, so if the laws just happen to have immigration consequences,
That's
okay,
fine.
But if you're focused on immigration
Correct.
policy, then it's
Well, there may be an issue as to whether the state has the ability to do that, which is what happened in the Arizona case. Okay? Any other questions? Any more questions, Nicolette? No? Okay. Anything else from anybody? Yes? No? No? All right, good. So what we're going to do now, class, is I'm going to hit stop on the record here, and we will take a little break. And wrap this up and come back in, let's say, 10 minutes, and let's start on the chapter on administrative and judicial review. All right, everybody? Thank you.